Hey y'all. Today I'm talking about the police lying to you. I've mentioned it before, and I actually had to make notes so I don't forget everything I wanted to mention, because I think this does relate to the Luigi case, and I'll get to that at the end. So first, can the police lie to you? Of course they can. But is it something they're getting away with? Is it some sort of trick? No, it's legal. It's permissible. It's actually constitutional. It's gone all the way up to the Supreme Court. So when we say it's constitutional, that means it has a basis in some part of the Constitution. Which part are we talking about? We're talking about the Fifth Amendment. So let's take a look at that Fifth Amendment. The Fifth Amendment, reminder, says no person shall be held to answer for a capital or otherwise infamous crime unless in presentment or indictment of a grand jury, except in cases arising in land or naval forces or the militia when in actual service of a time of war or public danger, nor shall any person be subject to the same offense twice, put in jeopardy of life or limb. And then here's the kicker, nor shall be compelled to any criminal case to be a witness against himself. Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. So, when we read the Fifth Amendment, we read that it protects against self-incrimination. That's your right to remain silent. You hear about Miranda warnings. You hear about that in Law and Order constantly. People read out your Miranda warnings. And common sense, we would think that protection just means that you shouldn't have to say anything to incriminate yourself, and that's it. But the reality is that this allows law enforcement flexibility in how they try to get you to talk. You have a right to remain silent, but the police, as long as they give you that due process, as long as they give you that warning, when you're under arrest, they can try to get you to talk. So let's go back to this landmark Supreme Court case, Frazier v. Cupp. In 1969, the Supreme Court dealt with a situation where police lied to a suspect about his cousin. They told him his cousin had already confessed to the crime. The suspect, thinking his cousin had betrayed him, ended up confessing. So what did the Supreme Court do? They ruled that police deception alone does not automatically make a confession involuntary or unconstitutional. What matters is whether the confession was coerced in a way that overwhelmed the suspect's free will. So lies on their own are not enough to violate your rights. Now, the key to understanding that is what's called the totality of circumstances. In other words, the courts have to look at everything that happened during interrogation. Not just whether the police lied, but whether other aspects were present. Did they physically harm you? Did they threaten to harm you? How long was the questioning? Was it prolonged? For example, if you were there for 10 hours, if they never gave you a break, didn't allow you any food, and they threatened your life, and they continuously coerced and questioned you, and they lied, then maybe the courts would uphold that and throw out the judgment. Then there's another case where this idea was reinforced. Illinois v. Perkins, 1990, an undercover police officer posed as a fellow inmate and got the suspect to talk about his crime. Court ruled that the suspect did not know he was talking to a cop. The deception didn't violate his Miranda rights. This case shows that even elaborate lies, like pretending to be someone else, can be legal as long as they don't deprive you of your constitutional rights. So you might be thinking, the police can say anything, right? Technically, no. Not exactly. There are some limitations. Under the Due Process Clause of the Constitution, the Supreme Court has said that anything that is so coercive that it shocks the conscience, or at least the conscience of the court, could be thrown out, right? Example, lying in a way that is emotionally and psychologically harmful will be a problem. Examples would be if they tell you that family members are still alive that have in fact already died just to keep you talking for whatever reason. That's a problem. So you confess and then you find out your family members are dead. Big problem. Another example would be if, say, they are accusing you of killing your child and They say that you have to tell them exactly how you killed your child so that they can save your child's life. Your child's in the hospital and they have to know the details of that. Otherwise, your child is going to die. Okay? Another example would be if they keep telling you that they're going to have to arrest your entire family, but they won't do it if you confess. These are all actual lies that the police have told before, and these are judgments that have gotten overturned because at that point, the suspect has been so emotionally and psychologically manipulated that there's no way to tell, especially with other factors like time, if their confessions were true or not. So here are the key takeaways. Yes, police can lie to you during interrogations. The courts have upheld this practice multiple times. They can lie about any of the evidence, just about. They can lie about fingerprints. They can lie about witness testimony they have. They can lie about having your DNA. They can go undercover and pretend not to be cops. They can tell you you failed a polygraph test and they know for a fact that you are lying. They can lie to you whether you're under arrest or whether you're not under arrest, and the police can lie to the public. The test is whether their tactics were coercive enough to overpower your free will. If that's so, then the only way to make a confession to be invalid would be that overpowering of free will. What's the best way to protect yourself? Ask a lawyer to come with you, because the minute you ask for a lawyer, they will have to stop talking to you until your lawyer gets there. And then your lawyer can remind you the entire time not to say anything because you have a right to remain silent. Okay? Now, final thoughts. The police have released a lot of information from the Luigi case, and I still need notes because I'm not going to remember all of this because it is so confusing what they've released, right? So within 24 hours of the murder of the CEO killer, CEO, United, they said that they had a water bottle, so possible DNA. They had a burner phone, a couple photos of the suspect, and those shell casings that are so famous now. They wondered if the gun might have even been a veterinary pistol. Originally, they said they could only get smudged fingerprints from the water bottle. Then, when they say they found a backpack, like the one in their photos, they said that there was a coat in it that looked like what the suspect was wearing and Monopoly money. Then when they arrested Luigi, they searched the backpack that was on his person then and found a 3D printed pistol, a 3D printed silencer, and a 3-page document, a box of masks, and the court prosecutors said that they found $10,000, which Luigi immediately disputed. Then the Manhattan DA started presenting evidence in the New York grand jury seeking an indictment. Conveniently, more evidence leaked out. Then they said that when they picked up Luigi, they also found a spiral notebook claiming responsibility. They said he was a match for the DNA and that they had good fingerprints. They say that the ghost gun found on him was consistent with the weapon used to kill the CEO and that that gun matched the spent casings. They say his clothes, mask, and ID found on him in Pennsylvania are very similar to the suspect in the videos. Despite the fact that previously they only had smudged fingerprints and they thought the pistol might have been a veterinary pistol. The thing is, we don't know if that's the truth or not because they can lie to us. All right? The police can lie to all of us. The police can lie to Luigi. The DA cannot lie, but the DA didn't say what this evidence was. Those are sources close to the DA. Additionally, there were federal charges, but they have to be honest in their complaint that was filed, but it's based off of the state law enforcement's investigation, but they don't actually have to provide all of their potential evidence. For example, they did not provide that picture of the suspect at Starbucks, possibly because it doesn't look like Luigi, nor does it look exactly like the other photos of the suspect. The problem there is, for all of us paying attention, you know that it all kinds of relies on that Starbucks analysis. But even then, say that it was Luigi that checked into the hostel because his mother said that he does like to go to hostels. That sounds like him. Well, a fake ID is just a misdemeanor. Say his DNA was on the Starbucks cup. I don't think a Starbucks cup killed a CEO. 3D guns aren't illegal in all 50 states, but he would have a gun charge in Pennsylvania. So far, the evidence they've presented doesn't connect him, but it is very circumstantial. But you should not trust any evidence they tell you until we see the chain of evidence, the chain of custody of evidence, and it's presented in court. We just can't trust what they say. They can legally lie. All right? Call your attorney if you've ever arrested. That's the key kicker. Talk to y'all later.